SJC-11986, Liliana Rivera Recinos v. Maria Isabel Recinos Escobar.
Good morning.
Good morning, Honors. My name is Elizabeth Badger, here on behalf of my client, Liliana Rivera Recinos. May it please the Court. This morning, we're requesting that this Court find that the Probate and Family Court has jurisdiction through its existing equitable and declaratory powers to enter what we refer to as special findings.
It seems to me that you're arguing if the court has jurisdiction, then ipso facto, your client is dependent on the court. That doesn't make a lot of sense, does it?
I think there are two separate issues. I think that there is jurisdiction, which we argue is existent under the courts, under the Probate and Family Court's equitable and declaratory powers. And then second is what is dependent? What does dependency mean under the statute? And we would submit that you have a dependent youth when you have a youth who's been abused, abandoned, or neglected and requires the intervention of the Probate and Family Court to remedy the detrimental effects of that parental behavior.
And how is the Probate and Family Court to remedy this?
I think that there could be a number of remedies. In this case, we're asking for declaratory relief to remedy the abuse, abandonment, neglect. It's within the competent powers that the Probate and Family Court has, and in this situation, it provides the most stability that the court can offer to a youth who's in this situation, who is between the ages of 18 and 20 years old.
What do you think the purpose of the federal requirement?
I'm sorry?
What do you think the purpose of the federal legislation insofar as it requires a state so-called juvenile court, which I appreciate here is the probate and family, that doesn't exclude the probate and family court, but what do you suppose if the purpose was to have the court make these findings?
I think, sure.
I mean, is it to indicate that in fact something really is going on in the court involving that person? Because basically what I understand you're saying is it's the act of making the findings itself that would be the remedy that the court is providing, as opposed to having some ongoing involvement with the person, which may be what the legislation contemplates.
Okay, so I think there's two questions. So what the reason that the federal statute asks the state courts to make this determination is because it is in the state court's expertise to address issues of abuse, abandonment, and neglect, to protect youth who are suffering detrimental effects from that abuse, abandonment, neglect, and to make a best interest determination. Best interest determinations are something that's part and parcel of what in Massachusetts the Probate and Family Court does. As to the remedy and the dependency issue, I think you have to look at it from where the child is coming from. Dependency results as a result of the abuse, abandonment, neglect. I think we should define dependency broadly to match the intent of the statute. What the statute intended to protect was that children who cannot reunify with one or both parents due to abuse, abandonment, or neglect, the remedy then can be something that is within the court's toolbox to provide. For certain children, it's going to be a custody order. For certain children, it's going to be support. It's going to be a case-specific determination. But here, what we're asking the court to decide is whether the court had the ability to enter the declaratory relief that Liliana requested.
It's not entirely a foreign concept, what the courts are being asked to do. What I have in mind is not a perfect analogy, but under Chapter 112, Section 12S, I think it is, the Superior Court is asked to make findings with respect to what are docketed as Mary Moe petition. They make findings as to whether or not a young woman who is still dependent on her parents and wants to get authorization from a Superior Court judge to obtain an abortion, and they don't want to involve their parents in the decision. But in those circumstances, judges make findings that are for the benefit of this child. It's a somewhat analogous procedure. It's basically make findings
But
so that something can be
why
done.
isn't your client emancipated at this point?
Well, 2 points. One, I would argue that she's not emancipated because she's still unstable,
But she's living here, she's got 2 children, she's on public relief,
on
public
mass
assistance.
health.
That's on what?
on mass health, yes.
Yes. Public relief.
Sure.
She gets health care and financial support.
That's
So
correct.
why isn't she emancipated?
Well, I think she's still,
Because she's living with someone? She's not emancipated?
she's living with an adult who's helping support her. I mean, the Eccleston court, in the Eccleston versus Pankowski case, recognizes that emancipation and dependency can exist for some purposes,
For sure,
but
and
not
that
for
court,
others.
that case is so different than this case. It's a child who from 11 years old was essentially in the custody of the state and other guardianship, who turned 18 and had no support from anywhere. And therefore, the court said, we're going to use our equity powers in this narrow area to fill a legislative gap, to say that support could be ordered beyond the age 18.
But I think that the Eccleston case is part of a series of cases where the courts have exercised their equitable jurisdiction to address a need that of specifically a post-minority youth who's been abused, abandoned, or neglected and suffered because of that, to address a need that's not specifically contemplated by the statute. And that's what we have here. In Eccleston, they granted support because that is what the child most needed in that situation.
Well, the court said she's this very small group. She's not to be viewed emancipated because she has no support. She's been in state custody essentially for 8 years. She's got no means of support. Her parents are able to support them, but because of their unfitness, she can't live with them. Isn't that different than this? I mean, your client seems significantly beyond that.
Well, first of all, I don't think we should hinge relief to these children upon emancipation or not. Emancipation has always been a token question of whether we offer support or not. It is not a question. It is not the token determiner of whether any kind of remedy can be available to these kids. And I think that the instability that Liliana suffered as a result of the abuse, abandonment, neglect of her parents has, placed her in this very difficult position, and I think it would be contrary to the statute to say we can't offer her a remedy to her parental abuse due to social factors that are connected to her parental abuse.
So can I ask you this, if we say, yes, the probate and family court can exercise jurisdiction and because she's dependent in the way that you say. And let's say that the federal government doesn't allow the special immigrant juvenile status. You apply for it, it doesn't happen. Can you come back to the probate court because you still have this person that you have, said is dependent and the court needs to protect her, in some way. So can you come back for other relief?
I think we have to use the remedies that are in the court's toolbox, and the amicus points out that there may be remedies such as referring someone to probationary services for help with a job search. But in some cases, there may be financial support that can be awarded. In her case, we've asked for declaratory relief. But to get to your point, I think that after we've expended the options for relief that the probate court can provide, and if immigration is to deny that application, then we're at the end of the road.
But why?
Why?
Well, the statute, I guess, permits somebody up to the age of 21 to receive this relief from the immigration authorities, correct? And if the probate and family court does not have jurisdiction to do it, then the statute would be thwarted in that there would be no state court which could make the finding that's required by the federal statute.
That's exactly correct, Your Honor.
So why do we need to make so broad a determination of dependency based on abuse? It seems that this person is dependent upon the probate and family court for this finding because
To exercise the federal opportunity.
otherwise there's nobody else who can do it.
I agree, Your Honor. You're saying that the court has competent jurisdiction. There are equitable and declaratory powers that the court has. There's nothing preventing it from exercising those powers to help youth in this situation.
Well, isn't that circular? You're dependent because we need your decision? So that
But I-
makes you
but I- but-
dependent on the court?
I think that the dependency is not coming from the court's perspective. It's coming from the child's perspective, where she has suffered abuse, abandonment, neglect. The Eccleston child was
How long,
dependent
she's been in
upon the
this
court.
country for how long? 4 years?
Approximately 3 years, 4 years.
Yeah, 3
Counselor,
years
can
up
I
here in
put you on the
Massachusetts.
spot a minute when you're done with Justice
Oh, I'm
Corday?
sorry. Go right
No,
ahead.
all right, go.
I have one more question, but I'll
Oh,
wait.
no, I'll wait for you. I'll wait for you.
Why isn't this a perfect case for asylum? I mean, why does the probate and family court have to be in the middle of this case?
I think the probate and family court has the duty to protect children who are abused, abandoned, and neglected, are suffering those detrimental effects, and are residing in the Commonwealth. It is the intention of the SIJ statute is the same as, you know, the mandate to the probate courts. We're protecting the same interests, and both the SIJ statute and our statutory scheme in Massachusetts acknowledge that children who have suffered these detrimental parental effects can continue to suffer harm after the age of minority. I think there is possibly a claim for asylum. I don't think we should have to resort to that.
You tried to, but what happened? How come that didn't
It's still
proceed?
pending. I mean, this is a form of agency relief. It takes a long time, Your Honor. And the fact of the matter is that Liliana shouldn't have to forego this right to a remedy to which she's otherwise entitled just because we're waiting on some other agency action.
Well, the right to
Is
the
it my
remedy, I
turn?
mean,
Is it my turn?
yeah, but just to be clear, with regard to the right is determined, it's not, this is determined by the immigration court, not by us. This is only to get you to the immigration court.
Sorry, perhaps the better word of it, she's otherwise eligible for this remedy if she is given access by the court in our state with competent jurisdiction to make a declaratory assessment.
Justice Hines, please.
You're calling on me now, okay. I'm going to put you on the spot a little bit because the question I have really arose from the amicus brief, which I found extremely helpful. And I'm sorry, the amicus is not arguing, so I get to ask this question to the representative of the amici. But what I wanted to know is this notion of dependency. I get it, the way that it's argued in the amicus brief. It makes perfect sense to me. But what I wondered was whether or not this construction of what it means to be dependent is consistent with how that term has been defined in other cases. In other words, is this a unique presentation that's being offered to us here, or is this pretty typical for this kind of situation?
I would say this is pretty typical for this kind of situation. And I think part of the issue is that in our federal statute, dependency is a term of art. It's not defined in the federal statute. It's not defined in Massachusetts. But the federal statute, I'm imagining, used it because it is a term, it is a form, it is a lingo in child welfare law. And in the states that do define dependency, they equate it simply to abandonment, abuse, and neglect. There are other states that use that language in their mandatory reporting laws, and they say if a child is found to have been abused, neglected, or dependent, they need to be reported to child welfare services. So dependency has this idea of a child simply being at risk. And I think that is the idea of the children that the federal statute intends to protect.
Was it meant to be the equivalent of a Chin's petition?
No, Your Honor. I think you can look at the language of the statute in its totality. So there are children who are in single-parent homes who cannot reunify with the other parent due to abuse, abandonment, neglect, and there may be situations where a custody order, for instance, is not available. a CHINS petition or a CRAW petition wouldn't be necessary in every single parent home. The determining factor for eligibility is whether the child cannot reunify with one or both parents due to abuse, abandonment, neglect. And so it's not always going to be, a CHINS petition. But I think the point is that
It means something other than custody.
it means something broader than custody, because to say that it's the same as custody would render that first part of the clause surplusage, and it would contradict the intent of the statute to say that we always need a custody order where the statute clearly intends to protect children who don't always need custody orders.
How is this to be litigated? The events occurred in Mexico. The father, who apparently was abusive, died 3 years ago. And you're saying essentially, well, the mother didn't really protect the child from the father, so therefore she can't go back.
So
How is that supposed to be litigated?
absolutely, sure. So the events happened in El Salvador.
Salvador, excuse me.
Sure. I would argue first that this is a unique situation where there was, horrific abuse. She came to the United States seeking protection
I
from that
take it with
abuse.
the permission and probably assistance of her mother?
No, not at all.
Not at all. She came to live with her brother.
She came to live with her brother. Then that brother for whatever reason, wasn't able to take care of her, and she comes to the Commonwealth to reside with a family friend who
Did she have her
offers to
two
take care
children
of her.
here in the Commonwealth?
I'm sorry?
Did she have her 2 children here in the
She
Commonwealth?
did, yes, Your Honor. She
Okay.
had them here in the Commonwealth. And so, the father died out of the alcoholism that was part of the abusive situation in which she grew up. I think that there's an argument that death can result in abandonment, which puts a child in the same situation as intentional abandonment. But we don't need to reach that issue because the statute says if she cannot reunify with at least one parent due to abuse, abandonment, or neglect, or that reunification is not viable or in her best interest, that's what satisfies the language of the statute.
I'm just trying to figure out how we litigate, how
Sure, so-
a court litigates this.
So here, my argument before the probate court is that, regardless of how you see the reunification issue with the father, the mother
Can't be reunified with the father. He's
can't be
died.
reunified with the father. I would argue that there is abandonment through death, but we don't need to reach that because the reunification with the mother is not viable, not in her best interest, because for all of her childhood.
Because her kids are here. I mean, I'm
No,
trying.
no, the question in the statute is reunification not viable due to abuse, abandonment, neglect, or other similar basis under state law. Abuse, abandonment, neglect of the parent. The mother, for her entire childhood, exposed her to this abuse by her father. There's no reason, there's no evidence to say that now that she goes back to El Salvador, that her mother's going to act in any more protective ways. The other piece is that the determination of best interest doesn't necessarily have to be linked to the abuse, abandonment, neglect. Here, the best interest determination will encompass things like her well-being in the Commonwealth, like the support that she's able to provide for her children now that she's here, the support that Ms. Mejivar, who's helping take care of her, has provided her that her mother could never provide her. And frankly, it's a very grim situation for young women in El Salvador.
So how do these cases get captioned? Does it have to be AB versus CD? Could it be in the matter of AB? Does it have to proceed like a regular civil case?
I would say
Can it receive expeditious treatment?
The judges, I would say the judges really want to help these kids, by and large. That is true. And so they are amenable to our motions to expedite cases. The captioning a little bit depends upon which court you're in and which clerk you're talking to, frankly.
Does notice have to go to the parents?
Yes, we always provide notice to the parents. Sometimes we have to do it through publication if parents are of parts unknown. Otherwise, we do, like a motion for alternative service by FedEx with a return receipt that we're going to provide to the court.
Does it, given that we're talking about general equitable jurisdiction and somewhere invoking the policy of the Commonwealth to protect children, which is a Commonwealth policy, couldn't this be in the Superior Court? I mean, in other words, why the probate and family? I understand why not the juvenile court, but Superior Court has complete equitable jurisdiction? What is special about the probate and family court?
I think it could be in the Superior Court, because what we're looking at the declaratory and equitable relief statutes, which say that the Supreme Judicial Court, the Superior Court, and the probate family courts, and I think it also says the land courts, have that jurisdiction, and that's the jurisdiction we're looking for to enter the declaratory relief that we're asking for. But I think that the probate and family courts are the most appropriate, because what they do on a regular basis is evaluate best interests of children and evaluate the abuse, abandonment, and neglect issue. So they, and I would argue also the juvenile courts, are experts on this issue.
But the juvenile court clearly wouldn't have jurisdiction if the child is now over 18, right?
Well, I would say with the exception of if you're in a delinquency proceeding and it has carried over to the 19th birthday.
Right, but I'm just saying, like in this case, you couldn't go into the juvenile
At this case,
court.
we couldn't affirmatively petition to the juvenile court, no.
All right, thank you.
There's legislation pending, is there?
There is legislation pending, Your Honor, and it's been pending for a number of years. And I would just say that, there is competent jurisdiction in the probate and family courts. So there's no reason we need to wait for legislation. And frankly, Liliana and some of my other clients and the clients of my colleagues cannot wait for legislation to happen. And what has happened in our discussions with the legislature is that some of our judges, the reason we initially my colleagues initially proposed legislation is because some, not all, of the probate judges say, I don't have jurisdiction. And so we go to the legislature, and the legislature says, well, counsel, can't you just do this in equity? And so what we need is a clarification from the court that our probate and family courts have competent jurisdiction under the existing declaratory and equity statutes to enter the relief that we're talking about today.
All right, thank you.
Thank you, Your Honor.